thekimbrownshow.com. There is a lawsuit being filed by R&B singer Robin Thicke. He is filing a suit against the estate of Marvin Gaye, the late, great Marvin Gaye. It all has to do regarding his hit song, Blurred Lines.
Everybody get up.
Now, if you're listening to that and you think it sounds a little bit familiar, well, maybe it does. Here's Marvin Gaye's Got to Give It Up. Now, you can definitely hear the similarities between the two songs. We're going to play some more of the clips from these two respective pieces of art, as they were, later on in the segment. But right now, we're joined on the line with Dart Adams. Dart Adams is a hip-hop historian. He's also a rap blogger. You should check out one of his latest pieces up on NPR.org celebrating the 40th birthday of hip-hop. Dart joins me right now from Boston. Good morning, Mr. Adams.
Good morning, Kim.
Also on the line, Steve Gordon. Steve is an entertainment attorney. He's also the author of the book titled The Future of the Music Business. He's the founder of Steve Gordon Law Group, and he's also a former director of business affairs for Sony Records. He's on the line from New York. Steve, good day.
Good morning, Kim.
Steve, help us out exactly. What is Robin Thicke, Pharrell Williams, and Clifford Harris, otherwise known as T.I., they are suing the estate of Marvin Gaye on what grounds exactly?
Well, Kim, they're seeking a declaratory judgment. They're not seeking money damages of any sort, but they want a judgment from the court that they didn't infringe Marvin's copyright. What's happening is that Marvin's estate has made a claim against Robin Thicke and Pharrell and asking for, well, we don't know what they asked for, but it was probably a lot of money. So instead of forking over that money, Thicke's people and Pharrell's people decided they would do a preemptive strike and go to the court and get a judgment that there's no copyright infringement and they don't owe the estate anything.
So, Steve, has the Gaye family or the estate of Marvin Gaye filed any complaints against Pharrell, Robin Thicke, or their record label behind the use of this interpretation of Got to Give It Up?
Well, not yet, but what's going to go on is that they'll probably provide an answer to the court to the complaint that was filed, I believe, August 15th. That would be the next step. And they will be arguing that, indeed, there was copyright infringement. Now, one interesting twist about this, Kim, is that Sony ATV controls the song as the publisher. Marvin Gaye wrote the song, but Sony ATV is the publisher. And for some reason, there's no seeking of a declaratory judgment against Sony ATV. So you could read between the lines and speculate that the Thicke and Pharrell people made a deal with Sony ATV, but not with Marvin's estate. And one of the claims in the complaint for the declaratory judgment is that the estate of Marvin Gaye does not have what you call standing to bring a copyright infringement case. And that could mean that the estate doesn't have the administration of the song or the control of the song that Sony ATV does, and that Thicke and Pharrell may have made a deal or are in the process of making a deal with Sony ATV.
So, Steve, to use some hip-hop terms to put this conversation in context, is Robin Thicke and Pharrell, are they saying that they did not bite Marvin Gaye's song at all?
Well, yeah, that's the primary argument, that there is no copyright infringement here. But the secondary argument, which may be the stronger argument, having listened to the two songs repeatedly, I think there is a lot of similarity, Kim. But the second argument may be the stronger argument that Marvin's estate just does not have standing to bring this claim.
Interesting indeed. Let's listen to some more comparative clips between Blurred Lines and Got to Give It Up. Here's Robin Thicke.
If you can't hear what I'm trying to say, if you can't read it from the same page, maybe I'm going deaf, maybe I'm going blind, maybe I'm out of my mind.
It's a catchy little ditty. Marvin Gaye. Now, Dart Adams, switching to you up in Boston. Dart, when we listen to those two songs side by side, I mean, obviously the audible similarities are quite evident. You know, both gentlemen are singing in a falsetto voice. Obviously, the tempo of the songs are very close, similar instruments, et cetera, et cetera. But can this be considered a sample or an interpretation of this record? How would you quantify this, Dart?
It's up to interpretation. It could be seen as an interpolation. It could be seen as a song that's inspired by the 1977 song by Marvin Gaye, Got to Give It Up. It could be seen a number of ways, and that's the reason why they went with the preemptive strike as suing, so we didn't infringe. Because Questlove said it the way that I could best describe it right now. He says, is the song derivative? Possibly. But that doesn't mean that they necessarily fit the song. If you listen to the whole argument in the manner of, okay, Robin Thicke is suing a dead man or he's suing his estate, everything sounds terrible. But from the music side, I completely understand why. Because the whole situation with sampling, interpolation, or copyright infringement, what isn't copyright infringement, it's a gray area that's up for interpretation, and at some point you have to make a stand.
When you talk about does the lawsuit itself sound terrible? Oh my gosh, yes, it sounds atrocious. When you look at exactly, you know, Robin Thicke is an R&B singer. Pharrell Williams is a longtime, you know, rap producer, hip hop producer, also of other genres. Come on, fellas, you guys have heard Marvin Gaye's "Got to Give It Up" before, so you can't say that there's no borrowing here. Steve, did you want to jump in?
Well, we don't know what the estate asked for. They may have asked for $1 million and 100% of the song. And, you know, the Thicke and the Pharrell just feel like they don't want to give it up, and they don't want to pay that price. And again, Marvin Gaye's estate may not have standing, so they're going to try to knock them out of the ring before the thing starts. But there is a precedent. Suppose Marvin Gaye's estate does have standing. The precedent would be the He's So Fine, My Sweet Lord case with George Harrison. So George inadvertently, and this is what the court decided after like 5 years of litigation, did copy He's So Fine. He didn't mean to, but he absorbed the song. And they found that the melody was so strikingly similar that there was copyright infringement. So I wouldn't, if I were a betting man, bet on the side of Thicke and Pharrell and a battle over copyright infringement. I think that the Gay estate may have the better side of that argument, but again, legally, they may not have standing.
Steve, when we talk about fair use and copyright protection, give us an idea, if you could please make those distinctions for the audience, because it can get rather confusing, because we know sometimes people have permission to use, you know, small snippets of already copyrighted works, and then other times artists who wish to either sample those works may have to go and seek permission or get clearance. So what is the legal process for this to happen in order for me as an artist to possibly borrow somebody else's work, even if it's just a snippet?
Well, I'm in that process now, and it's not easy. It's not simple. It's one song by a fairly famous rapper, and there's one record company that I have to get permission from, and then there are two prominent publishers who jointly control the underlying musical composition. So to use this one rap song, I've got to get three parties to give permission, and it's been 4 weeks, and they're still in the process of figuring out who the right person to handle this claim of this request is at these three prominent music companies. So it isn't simple, but it is necessary because in this case we are sampling. We're actually using the recording as well as the underlying song. There's no question that we have to get permission. Now, you brought up the issue of fair use. Well, there are two doctrines that compete against the right of a copyright owner to license a sample. Those two doctrines are the de minimis use doctrine and the fair use doctrine. So the de minimis use, as it sounds, means if you only use a little bit, Kim, of a copyrighted work and it's incidental to the main work, you don't need permission. Well, that defense didn't work in a case called Bridgeport, where the Bridgeport Publishing Company, which bought out George Clinton's catalog, brought over 500 copyright infringement claims. And the court in Nashville said that even if you use a second of a recording, it's a copyright infringement. Now, the court remanded the case to the lower court for a fair use determination. It didn't say that the defendants were going to have to fork over money. It said that the defendants would have to prove fair use in each case. And all those cases were settled. So when we get to fair use, we get to a Beastie Boys case that occurred in the 90s, in which the Beasties were alleged to have copied a song, and the judge, this is in California, held that it was an incidental use and that they didn't take the core or the essence of the original song. And in that case, the judge held for the Beasties that there was fair use.
Dart Adams, we know the practice of sampling has been pervasive in rap music for almost since its inception. However, the use of sampling and the method by which rappers either obtain the samples or just use them in general changed in 1991 with a court case called Grand Uptight Music versus Warner Brothers Records. Can you fill us in on what happened in this case? This was involving Biz Markie, and this was a big deal in rap music at that time.
Huge deal. It changed everything. December 17th, 1991, the ruling in Grand Upright Music Limited versus Warner Brothers Records Incorporated pretty much stated that if you sampled something, you had to have it cleared, and or you had to have special permissions. And then when you had your album released, which is something that did not happen previously, you had to have all of the samples listed in your albums, liner notes, what have you. This changed everything because before that, in hip-hop and rap music, you released your album, people had to guess what you used. And it meant that you went to record stores, you listened to other music, and you had to find what every piece was. When you listed all the samples, that meant that everybody ran out and they started sampling or looking for the specific records that were sampled, and it changed the rap game entirely. That's when interpolations became popular, where you had to get a studio musician to come in and play certain compositions. Or if you didn't want to have to go through that, what you did was you just had a band and they played music and you rapped over it. This is why the Roots were able to have a foothold in rap, because it brought in bands. Justice System, the Roots. We had already lost Stetsasonic. Another thing happened was that it led hip-hop fans to go find new records which weren't previously sampled, which weren't being discovered, which weren't appearing in liner notes. And that set off a whole new round of producers finding new ways to chop and or flip samples so that they were indistinguishable, so that things that happened at De La Soul before couldn't happen again. And on the underground rap scene, where they're not selling enough albums or getting on the radio enough, where huge corporations will come after them for samples, and they're using songs and recordings that are so obscure that they probably couldn't find them anyway, then sampling is still alive and still going well. And songs are being chopped and sampled and flipped to a point where they're completely indistinguishable. So it's not the same issue as a court coming after them for use. However, albums that were released past a certain time, people are writing blogs and things about that, talking about what songs were sampled. And now you can come back 15, 20 years after the fact and sue these record companies for releasing songs where the sample wasn't cleared because they had a certain window of time to release the album. So it's this big Pandora's box.
Well, I wanted to give the audience an idea about that lawsuit. As you said, Grand Upright Music. I think I said Uptight, but Grand Upright Music versus Warner Brothers. This is the lawsuit that set Biz Markie back a grip in the rap game for a bit. Now, this is Biz Markie's Alone Again. I believe this from his 1990
album. Alone Again Naturally from, Gilbert O'Sullivan.
Here's Biz's account of Alone Again Naturally.
I had nobody to help me, as you can see. I'm alone again, naturally. Alone again, naturally.
And here's Gilbert O'Sullivan's Alone Again Naturally, the original version.
We may
'cause I did on my own, alone again. Naturally, to think that only yesterday I was cheerful, bright and gay.
Now, fellas, I want to ask this question to you both, because when we talk about the use of sampling or even covering records, I'm sure that what Robin Thicke and Pharrell did with Marvin Gaye's song falls under a little bit of a different umbrella, but it's still very closely related. I mean, this is big money we're talking here. I mean, you got to get the sample cleared. Either the publisher who holds the ownership over the music gets paid, or the original songwriter gets paid. Steve, when we talk about getting samples cleared, how much money are we discussing here, and who all is in line to possibly get paid from using a sample or just covering a record outright?
Well, that's a great question, but there is no easy answer. So I'm asking for my samples, and it's a charitable use by an organization for music for kids, for $750 for the master and $750 for the song. I wouldn't be surprised if it ended up at $1,500 each. But again, this is a not-for-profit use. So if you're Puffy and you're sampling, and he does, then it could get into thousands of dollars or tens of thousands of dollars. Kanye West people won't return your call if it's less than a certain number of zeros, for instance, okay? So it ranges depending, of course, primarily on the identity of the song. So if you're sampling some obscure Caribbean music from the 80s, then you can expect to get a quote of $1,500. But if you want to use Kanye, then you got to add at least another zero. And we don't know what the estate of Marvin Gaye wanted for the use of the song. But I would like to amplify my answer about fair use for 1 second, if you allow me. There's an artist called Girl Talk, and what he does is he does mashups live, and there's no issue about sampling there because he's doing things live. He's not creating another copyrighted work. But he's also released several albums. Now, he lets people choose to pay what they want for these albums, but they all contain mashups. And nobody has sued him, even though he's using some of the most famous songs and commercially successful songs in the world. And the question is, why hasn't anybody chosen to take up the gauntlet and sue Girl Talk? And the reason is that he might win the case, and he might win the case on the basis of fair use. Now, fair use is a provision in the Copyright Act, but it's very general, and it states things in broad outline form, that the use of a copyrighted work for news or criticism, or if you only use a little bit, then you can claim it's fair use and mount a good defense to copyright infringement. It wasn't intended because it preceded sampling. The law was passed many years before anybody was sampling, but people have
Also, the law has been updated.
fair use.
The law has not been fairly updated going along with
No, the law has not been updated, and Hank Shockley, who's famous producer of Public Enemy, makes a really good point that the people who are making money from the licenses for sampling are not necessarily the artists or the songwriters. It's the big music publishers and the record companies that represent them, and both the songwriters and the artists may be unrecouped. In other words, they may owe their record company or their publisher money, so when the publisher and the record company get the money for these licenses, they don't necessarily share it with the artist. But to go back to Girl Talk, the reason why nobody sues him and they think that he might win is that he uses the samples in a way that is so-called transformative, which is a new doctrine that's been created by the courts in copyright cases or fair use cases. So it's a new work. It's truly original in that it's using the old works but creating something entirely new. It may be deemed to be transformative and thus fair use.
When they chop or something, or they flip the sample, it is transformative. And they don't put it under that same umbrella. So I always had issue with that because it works. They applied for Girl Talk, and they're afraid that he might win the case. But that's the case with 75, 85% of hip-hop when a song is simple. They change the original composition into another composition, so it should fall under the same precedent.
That is an argument. That is an argument, and at the other end of the spectrum, if I write a copyrighted song or do a copyrighted recording, then I'm entitled to compensation. If I don't get it, then I might not be inspired to create anything else.
Dart Adams, I want to pose this question regarding Robin Thicke in his lawsuit against the estate of Marvin Gaye. How is this going to play amongst fans of R&B music? How is this going to play amongst people who know Marvin Gaye, his legacy, tragically even his murder, and who hold him in a very, very distinct reverence when it comes to, being the forefathers or one of the greats of R&B? I mean, are Robin Thicke's arms too short to box with the god Marvin Gaye on this issue?
The problem with this particular case is that from a personal standpoint, I hate the idea that this is happening, and you can have a knee-jerk reaction and just say, I can't believe Robin Thicke and Pharrell is suing Marvin Gaye. But if you're going from a purely music, as someone who knows the music inside and out, this was inevitable. This was inevitable. I mean, if we flip this on the other side, look at what when Rolling Stones made a song called "There Goes My Baby." It sounded like "Constant Craving" by K.D. Lang. What happened was they played the song for their kids. Their kids were singing K.D. Lang's "Constant Craving," so they listed K.D. Lang as a writer and gave her publishing on the song they made when they didn't know that song, but because they heard other people heard it and automatically started singing the other song they didn't know, they did that preemptively. So it all comes down to, if you understand the music business, which unfortunately most fans don't, and you understand why this happened, and you know that it was going to be inevitable from the first time I heard "Everybody Get Up," doom, 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 doom. I was like, wow, I love that song back in 1977 when I first heard it, Marvin Gaye sang it. But as bad as this sounds, this is almost necessary, unfortunately, because it's about business and it's about money and not about the music.
Indeed.
The music industry is always about the money and the business.
Without question. Steve, we have about less than a minute to go, so give me like a 30-second answer if you can. What are we likely to see is going to be the outcome out of this lawsuit? Are you predicting this could be settled out of court and never even see a trial?
Probably. I actually called a musicologist friend of mine, a very prominent musicologist in the United States, and she couldn't comment on the similarity or the chances of success in a copyright infringement case because she's probably involved as an expert. But what it is they call upon musicologists to compare the songs and see if there's substantial copying. I don't think it'll get that far. I think this is all about the fact that the estate asked for too much money and that this preemptive strike is all about the fact that the estate may not have the right to actually make a claim, that it may all be through their publisher, and that it may come out that the Thicke and Pharrell people took care of the publishing, and they don't want to shell out any more money. And I think that this will be settled, and I don't think anybody will ultimately win this case if it goes to trial, except the lawyers.
Indeed. Well, that's our time. Gentlemen, that's Steve Gordon. He's an entertainment lawyer. He is the former director of business affairs for Sony Records, also founder of the Steve Gordon Law Group, and he's the author of the book titled The Future of the Music Business. Also been joined on the line with Dart Adams, prominent rap historian, hip-hop blogger. You can catch his Tumblr, bastardswordsman.tumblr.com. Dart, Steve, I appreciate your expertise and your time today. Thanks a lot.
Thanks, Kim.
KimBrownShow.com.